Hey everybody, this is Sean Henricksen here at the Sean Henricksen Law Firm. We help good people avoid the devastating consequences of criminal charges. Today we are talking about your right to a speedy trial if you're being charged with a crime. When you're charged with a crime, you've got several rights. One of those is the right to a speedy trial. And basically the reason for that is because the longer the time between an alleged offense and a trial, the less reliable that trial is going to be. There are witnesses who may not be available to testify anymore. There's evidence that we may not be able to find. And people's memories may have faded or changed a little bit. And so they may not remember something a lot later on that they would have remembered better if the trial had been sooner. Now, when the courts are looking to see if your right to a speedy trial has been violated, they're looking at four different things. The first thing they're looking for is the length of the delay. If it's been a really long time, then it's more likely that your right has been violated. If it's just been a short or maybe even a medium period of time, then it's going to be less likely that your right has been violated. The second thing they look at is the reason for the delay. Was there a good reason why it took this trial longer than normal to happen? If there's a good reason, then obviously it's going to be less likely that your rights have been violated. If the reason is that the state's just been dragging their feet, then it's going to be more likely that your right has been violated. The third thing the court's going to look at is, have you asserted your right to a speedy trial? Have you actually asked the court or let the DA's office know that you want a speedy trial? Normally, the way that we do this is having it in one of our motions or during one of your court appearances, then putting it on the record that you want a speedy trial. If you assert your right to a speedy trial, then it's going to be, and everybody is aware of that. If you don't get that speedy trial, then it's going to be more likely that your right has been violated. If you don't let anybody know or put anybody on notice that you want a speedy trial, then it's going to be less likely that your right has been violated. The last thing, and one of the more important things that the court is going to look at, is have you been prejudiced by this? What negative impact has the delay in trial had on your case? Are some of those witnesses no longer available that would have been available to testify? Have you undergone some sort of stress related to this charge? Has it had an effect on your job? Is there some other way that dragging this case out longer than normal has negatively impacted you? When the court's making that decision on whether or not your right has been violated, they're going to look at all of those different factors and see what weighs in favor of you and what weighs in favor of the state. Now, one reason why this is even more of an issue right now is obviously we've got the pandemic going on. The courts are shut down, people are still getting arrested, but as of right now, they're not having any jury trials. And so everybody's cases is going to be delayed longer than it normally would have been before the pandemic. Now, obviously, the factor that this is going to go to is going to be the reason for the delay. If the only reason that your case is being delayed is because the court's not having jury trials because they don't want to have large groups of people coming together in small spaces, then that's not going to probably get you the dismissal that you're looking for. But what I think is going to happen is once the courts open back up, I think all of these cases that have gotten backed up, so the courts are going to be backed up, the DA's offices are going to be backed up, that certain cases are going to be neglected. And I think that that's when we're going to start seeing speedy trial issues. What you need to be doing right now, or what your attorney needs to be doing right now, is looking at those four factors and finding out what we can do to lay the foundation to make a good argument in the future. So first off, obviously we need to be asserting that right to a speedy trial, letting the court and the DA's office know that you want a speedy trial. Secondly, we need to be keeping track of how is this affecting you? So is this affecting your job? Are you having more stress than normal? How many times are you having to check in with pretrial services or with your bail bondsman? And how is all of that affecting you? Are you having to take days off to check in with pretrial services or with your bondsman? And we need to keep track of all of that so that when it does come time to argue that your case needs to be dismissed because of a violation of your speedy trial rights, then we've done what we can do to make sure that you've got the best chance of winning at that argument. Because ultimately, the remedy for violation of your speedy trial rights is to have the case dismissed. If you have any questions about your right to a speedy trial, or if you've got a case that's pending right now and you want to talk about your case and how your right to a speedy trial may be affected right now, give me a call. My phone number is 210-900-2806, or you can click down in the notes where there's a link to set up a free consultation. Have a great day.